open. Please be seated.
Thank you. So, call the 7th case for today, which was continued from last week. You folks missed a nice session down in Dartmouth. We had a very nice time at UMass, and probably it's more convenient for both of you, too. But at any rate, I'm calling 24P31, which is FURNARI versus Holden.
Good afternoon, Your Honors, and I would like to thank you for granting me that favor so I could attend the personal event. Your Honor, I represent Mr. Patrick FURNARI, and prior to 2022, Mr. FURNARI and Mr. Holden were basically partners in two businesses. One of them was Automatic Machine Company, which was a tool manufacturing facility in which Mr. FURNARI held a 29% interest and Mr. Holden held a 71% interest. They were also co-owners of JH Valve Realty LLC, which was the owner of the real estate occupied by Automatic Machine. And in that particular entity, Mr. FURNARI had a 49% interest and Mr. Holden had a 51% interest. Beginning in about 2021, various disputes began to arise between Mr. FURNARI and Mr. Holden, basically over the management of JH Valve. And the disputes all centered around Mr. Holden's in substance preferring preferring Automatic to, and the benefiting Automatic to that of JH Valve.
Right, so we're here over this shotgun clause that says you have to make an offer giving the value of a percentage, 1%, right?
Yes, Your Honor. So
is there any explanation for why they had that requirement to be a percentage as opposed to the value of is it because they had unequal shares? Is that the issue?
Your Honor, the original clause was obviously in the very first, in the initial operating agreement between the parties, and it was to address if there was disputes, fallings out among the parties, as opposed to trying to go through dissolution. The 1%, I don't believe, had any impact on the percentages because you were going to value your 1% share.
Right, but I mean, normally the way a shotgun clause works is you make an offer and the other side decides whether to be bought out or to buy out, right? And I guess because they didn't own equal percentages, the only clearest way to do that would be the 1%.
The only clear way to do it would be to come up with a value per interest, yes, Your Honor. And the question that rises here, though, is where they were 49 and 51 and where there was a number provided in the initial buyout offer, it was easily calculable to determine what the 1% was worth.
So, I mean, on page 12 of your brief, you say, an unambiguous operating agreement should be enforced pursuant to its terms. And the terms of this say, by stating in notice the price per 1%, which he does not do. Why shouldn't we enforce it by its terms?
Your Honor, because this is, first of all, it's not, quote, I don't think it's not in the context of a settlement, it's not the context of an offer just per se. It's in the context of the operating agreement and the provisions of the operating agreement, and as the court referred to, the shotgun clause that's in the operating agreement. I agree with the court if there was no shotgun clause in the operating agreement and Mr. Holden made an offer as he made in the email, that Mr. FURNARI would either have to accept or reject that offer.
What do we do with Judge Sullivan's analysis of the shotgun clause where she says that the may pertains to the offer, but the shall pertains to the notice?
Your Honor, I don't think that in and of itself is determinative of whether or not the notice was effective. The court did make reference and asked us to comment on the, it was Source, get the specific setting case, it was the Source Unlimited Inc. versus Cummings property case. And in that particular case, I think addresses the question you just raised. In that case, that arose out of a lease arrangement, but in that lease, there was a specific provision dealing with if you were going to exercise your option to renew the lease. And that had very mandatory language which said, if you're going to exercise the option, you must serve the notice by constable. And then it had additional provisions which said, excluding specifically any other types of arrangement. So that particular lease had some very express provisions with how you go about to exercise the option. What the court said in Source, and what this court said in Source, was basically that if you have an option, which is mutual, either side can elect it, then we are not going to apply the same strict compliance standards that we have applied in other option cases where it was unilateral. In this case, it was mutual. Either party could have elected to give the shotgun notice, and either party could have elected, if it was given, the other party could have elected to either buy or sell the particular interest. So I would, in answer to your question, the shell I don't think is determinative of this particular decision. And in fact, I think the court's reliance, the lower court's reliance, the trial court's reliance on the word shall, in fact, is the cause of the error here. That the appropriate standard was not the strict compliance that the trial court complied, but a more flexible standard that was enunciated both in the Source case and other cases both cited in course and related to Source, plus within the theory of the cases that we cited in our memorandum about having a reasonable practical application and reading of a contract.
So let me ask you, the email that you say triggered the shotgun clause was titled settlement offer, and in addition to making the $1 million offer for your client's interest, it also offered to settle a lease disagreement for another $160,000. Suppose instead of saying settlement offer, the email had started by saying, in no event shall the email I'm about to send you be construed as an offer or intent to purchase under 707. Would that, and then they went on to say, I'll give you $1 million for your 49%. Would that trigger the shotgun clause? If they said I don't intend to?
No, Your Honor, I don't think the intent that the shotgun clause deals with, well, two things. First of all, policy reason is to have a structure for resolution outside of judicial dissolution. But the clause itself deals with whether you are going to make an effort to buy out the other side. And it's very specific on what has to be given. It's not a question of intent. It's not a question of whether you have to say, I'm doing this under 707. It's not the intent to reference 707. It's the intent to exercise and buy out the other party. The provisions that are relevant here.
In the response email, FURNARI put that very same language and said, so that was the first letter that actually said a 1% number, but don't take this as an initial offer. I mean, why not?
Well, because, Your Honor, we were responding specifically to the buyout offer that was provided to us. Under the shotgun clause, we had to respond one way or the other. We either had to, A, accept the $1 million for our shares, or we had to offer to buy Mr. Holden's shares. If we did nothing, we would have been subject to the buyout. We would have had to sell the shares for $1 million. So what we have here...
It's not a shotgun clause, it's a gotcha clause.
Well, I don't think it's a gotcha clause because it was in the original agreement. They were represented presumably by counsel. This was not drafted by individuals. It's a very detailed operating agreement. It shows a level of sophistication and legal acumen in drafting it. It was clearly intended to address these kind of issues.
So Holden argues we can affirm on other grounds because the email between counsel and the alleged counter-election that got mailed to the Taunton office instead of Holden's home address complied with the operating agreement's notice provision, section 12.02, requiring it be addressed to a member. What do you say to that?
Your Honor, I don't think that, again, it's relevant. They were addressed to the specific members here. I'm not sure exactly if I understand the relevance of that particular section to the issue before the court.
Well, it is addressed to Holden at 400 Constitution Drive and not at his address listed in the Secretary of State filing, listed in the certificate organization, listed on Schedule A of the operating agreement as an Attleboro address.
Yes, Your Honor, but that's the same issue that's arisen before, and the question of if you send the notice, did he get the notice? Was there actual notice? Was there any confusion over the notice? And the specific provision is not, particularly, it is not such a deviation as to vitiate the proposal.
Was AMP still operating at the property when the response was sent?
Yes, as I noted, I believe we noted in a briefing, and I was about to state in the argument, there was litigation over the lease and whether the lease was properly terminated, and there was this litigation went on for almost a year. It was in the context of that litigation and fairly early in that litigation that the buyout proposal was made. So yes, AMP was still in the property and remained in the property for a number of months. It didn't pay any rent for a number of months and violated a preliminary injunction, but it was in the property and it was operating. One thing I would like to point out to the court is that the facts of this case are somewhat unusual. Typically, when a case comes up on this type of issue where you have a question of the exercise of an option and whether or not the exercise complied with the provisions, the party who's contesting the sufficiency of the notice is the party who received the notice and is the subject matter of the notice. In this case, you have the party who in fact drafted the notice and sent the notice and put the wheels into motion is now saying, oh, wait a minute, I made a mistake. I didn't really mean this. I didn't mean to trigger 707, and I don't want to be held I don't want to be held responsible for what I in fact said and intended to do.
So we do actually try to deliver justice here, and I'm really puzzled as to what the just result in this case is. Why is it just to interpret the provisions the way you suggest?
Well, I think, Your Honor, I believe it was in the Source case. I'm sorry, I think it was in the Westinghouse case. I think that was the cite on it. But in substance, Your Honor, it's a question of law and not a question of equity. This is not an equitable rule where the court's going to apply equity to the case. This is a question of law, of interpretation of the contract, and equities do not necessarily weigh one way or the other in influencing the decision. If, in fact, this was a buyout, the specific terms trigger, and it goes down the line, and it's not a question of equity.
Did anything say that you had to specifically mention Section 7.07?
I'm sorry, Your Honor?
Did anything say that the person making the offer under the shotgun clause had to specifically reference Section 7.07?
Not by Mr. Holden, only by Mr. FURNARI. Again, I don't think that was necessary to specifically reference the section. The section had really only three conditions because it's a notice of offering or an offering notice. And the three conditions were, A, that there are only two members, B, that they send out a writing, and the writing is an offer to buy, and then with the amount that they're offering to buy the stock for. It's intended to, it's almost as if you have one person cuts the pie and the other person takes elects which slice they want. It's somewhat similar to that type of provision, Your Honor. And that's why it was there for. And I go back to the fact that this case comes up under a very different set of circumstances because the person who sent out the offer is now challenging the sufficiency of what he sent out. As also, I think the trial court erred because it applied a strict compliance standard, and I think the case law of this court, looking at Source Unlimited and the cases cited therein, make a distinction between unilateral and mutual. This was clearly mutual. It should not have been a strict compliance. The question should have been, was the nonconformity consequential to the results, and did it in some way, was it contrary to what the intent and purpose of the provision was? And I would say that the putting down $1 million with a per 1% amount is easily calculable, and the fact that there's clearly an intent to buy out, that would be consistent with the provisions of 707. And therefore, it was an enforceable offering notice of which Mr. FURNARI then had the right to respond to and either sell his stock or buy. The simple question, one of the questions here is if Mr. FURNARI did nothing, would it be Mr. Holden that would be standing up in my place arguing that it was a sufficient notice? I don't really think you can have a situation where he basically can have his cake and eat it too. He can say, well, yeah, it was an offer, but it wasn't an offer under this section. I see my time is up, almost up. If there was any additional questions, Your Honor.
Seeing none, thank you.
Thank you. I would just request, Your Honor, that the trial court be reversed and the matter be remanded. Thank you.
Members of the panel, good afternoon. Joe Downs on behalf of the appellee, John Holden. The court should affirm there's no reversible error here. The trial court correctly concluded that there's no plausible claim that by the June 1st, 2023 email, Mr. Holden invoked Section 707 of the operating agreement. And there's no amount of time, discovery, or voodoo that's going to change the nature of that email, that global settlement offer not admissible, into a Section .7 election within the meaning of the operating agreement. Now, the emails
Are you saying we shouldn't consider it because it was a settlement offer?
No, Your Honor, but that's emblematic of what it was intended to be as opposed to a statement of intent to make an election, which is a requirement under 7.07. If you look at Section 7.07 and what it requires, if they're one of two members in JH Valve, they may elect to purchase the other member's shares. Now, that's permissive, but they do that in the first instance by giving notice in writing of the member's intention to make that election.
So did they have to name Section 7.07?
That would be the preferred way to do it, but they could do it other
Well, it would be,
ways.
but if they didn't?
They could make that intent clear in other ways. They could
Well,
say,
if the letter that you got said I'm offering you X amount of money per percent, would your client be out of luck then?
it would certainly make it a closer question because that would be unusual to do it that way, and one might be able to reasonably infer that they're invoking 7.7.
Well, what's the difference between, like, assuming that your client, well, assuming his client owns 49%, what's the difference between you saying I'll give you $1 for each percent you own, or me saying I'll give you $49 for your interest?
Well, the difference matters in relation to what the intent was by that email. And the requirements of Section 7.07, there are multiple requirements. And by any measure, they haven't satisfied any of them. The email, that is. It flunks the test in every respect. My client's position is 7.07, what are they talking about? This isn't an election. No one was doing that. I'm making a global settlement offer in the context of JH Valve and automatic machine products. JH Valve's the landlord. They're trying to evict AMP from the space. And they're saying, you need to amend the operating agreement, you need to do this, you need to pay taxes, you need to pay FURNARI. And the client responds and says, I want to achieve a complete break, a complete separation here. I'm going to have a global offer that addresses a bunch of things. And it also is conditioned upon financing, and it contemplates a closing at some date in the future, right? And what they've done is cherry pick one portion of that. All it has is a dollar amount and mentions the shares. That's it. Nothing about it satisfies any of the requirements.
What do you say to your opponent's argument that if they had not treated it as an invocation of 707, then you would have turned around and said, ha-ha, it
That's
wasn't
an argument. It's an argument that doesn't really play out for two reasons. And the first one is the first thing we said is that, what are you talking about 707? And it's them that went to court. This is a gotcha moment. That's all this is. They were lying in wait, apparently, when they received this and said, oh, we're going to treat this like a 707. We said, this wasn't a 707 election. And then rather than putting down their sword, they ran to court. That's the first piece. The other thing I think, Your Honor, is thinking about this, taking a step back. It's stated directly in that email that the intent of that email is to have a complete separation. And part of that is an offer with multiple features.
Right, but if you take the other company out of it, I mean, 707 also achieves a complete separation.
It doesn't, though, and here's why. It doesn't, because if you're not making a global offer, but you're saying, I'm making that election, you're taking a gamble. And the gamble is that FURNARI is going to turn around and say, no, I'm going to buy you out for that price. And it does the opposite of a separation because he remains the landlord who's still intending to evict automatic machine parts. So doing an election makes absolutely no sense here. If he accepts it, okay, maybe you get what you're looking for. But if he doesn't, which he didn't hear, he remains the landlord. He's able to evict us. That's the opposite of what's the stated intent of this email, which is to have a complete separation, a path forward to that complete separation, Your Honor. So we have the first instance of what's required under 707, and that is if you're going to make the election, you have to give notice in writing of the intent. There's nothing in this email that gives any suggestion that this is what the intent is. It doesn't say that. And for that reason, I think you can stop right there. What it also requires is if you're going to make that election, if you make that statement of your intention in writing, you also have to deliver the other requirements, which is the percentage and willing to give, willing to accept. It doesn't include any of that. All this is the run-of-the-mill settlement offer that has one portion of it that addresses J.H. Valve's interests. It has contingencies. It contemplates a future closing date. There's simply nothing from which the court can or should infer that Section 07 was implicated.
Does the contingency make any difference? If he had said, I'm invoking 707 and I'll buy you out at X dollars per percent contingent on my getting financing, would that make it not a proposal under 707?
I don't know that it would. I mean, he doesn't have the money to purchase them out at that day. So I don't know what happens in that instance, but you shouldn't make an election under 707 unless you have the money. And he clearly didn't have the money because he's saying, I need to get financing to pay this out in the context of a global
But that would, I mean, we see
resolution.
these kinds of, clauses all the time. I mean, they can be very common in a real estate agreement when 2 people or 4 people buy a house or place to live together. They always have to get financing. So you'd be basically taking this kind of clause off the table.
Well, you'd have to circle back to the language of 707, which is what's required here, right? I'm not sure financing actually would be required for a Section 707 election because it contemplates payment by a note over the course of a number of years, depending on the amount that's there. So, but that's not what he was doing, and it goes back to what Section 707 requires, which my client has never said that's what I was intending to do, and the fact that the email that they're saying is the election satisfies none of those requirements, not one of them, that there's no basis to conclude that it was a Section 707 election, and there's no error by the trial court in making that conclusion.
What does it mean in the email that says to get a complete separation, which will also take out Webster 5? What does that mean, which will also take out Webster 5?
Webster 5 was the bank that needed to be refinanced, and I believe Webster 5 had loans that were cross-collateralized by the assets of both AMP and J.H. Valve. And Webster 5, I believe, was the bank that was referred to in the prior email by Mr. Bennett, saying, if you don't do these things, we're going to tell the bank that the lease is terminated and there's a default under the lease. I believe that's what they're referring to there.
So did the trial court err in finding that only a single lump sum, including an amount for the intercorporate debt, was offered when the offer on its face offers separate figures of $1 million and $160,000?
Yeah, I guess there were 2 lump sums that were there. There was the $1 million, and then there was the sum of the $1 million and the $160,000. I think they referenced, the trial court referenced the wrong lump sum when making that statement. It doesn't affect the analysis at all. So I think, and there's nothing to conclude to say that if FURNARI's math was right, the result would be the same. Addressing, Your Honor, the Sources Unlimited case, which I think is helpful to discuss. I think it's largely distinguishable in the fact that we're talking about in that case the method of delivery. And the method of delivery, I believe, we discussed in footnote 4 of our case. But it is not something we're standing on. It's not the basis we're looking for this court to affirm on. But in those cases where the actual timely receipt of the notice was received, but more importantly, the intent The intent of that notice was not at issue at all. In this case, the Sources Unlimited case, it was Cummings was the landlord, Sources Unlimited was the tenant. There was no dispute that Sources had sent the notice not to renew the lease on time. There was no dispute that unambiguously that's what they were intending to do. And the fact that the court looked at that, it canvassed some of the other cases and said, registered mail versus certified mail versus email. This email they sent accomplished everything that was intended by the notice, and everything else was in place. It was the gravamen of the option, and therefore correctly concluded that the method of delivery was inconsequential. Now contrast that here, Your Honor, where the deviations are material. It goes to the heart of the provision of Section 707. It's the content and the nature of the email. And ignoring those requirements in Section 07 would contravene the crux of that option provision. So if you think it's probably a little bit closer, Your Honor, to the Cadillac v. Stout case that was cited within the Sources Unlimited case. And in that case, the court refused to enforce the optionee's attempt to invoke the option because the deviations in the notice that it provided were material. Now, importantly, I think in that case, there was no question that the optionee, that's what the optionee was intending to do, trying to invoke that option. But instead of giving material, including material provisions in that notice, like the date and hour for the delivery of the deed, or the time to commit to a close within a specified period, the optionee instead said, our attorneys will figure that out. But the intent was clear. And the court nonetheless said, nope, we're going to hold you to the usual strict adherence that's required here. The manner of exercise is determined by the language of the provision. And in that case, they found there was no reason to depart. I think there's even less reason to depart in this case. And I believe the Cadillac v. Stout, it just further confirms the correctness of the trial court's decision. Unless the court has further questions, we'll rest.
Yeah, is this, I mean, is the key issue here intent?
I think it is the first issue that is required by 707, which is you have to state your intent. And it makes sense because this is a shotgun. You're in. Once you're in, you're in.
Right.
And you've got to either buy or sell for that price. So this is an important requirement that needs to be followed, and it explicitly required by Section 707.
I'm just trying to play this out. Suppose we were to say that, you know, Mr. Bennett's argument, it's not frivolous, it's plausible. Like, you know, $1 million is pretty easy to divide by 49, and there was an intent to do a complete buyout of his client's interest. So what if we, you know, if we were to say, no, that's a plausible claim, we shouldn't have been dismissed, and then it goes to summary judgment, and your client says, I never intended to use the shotgun, and he's going to say, well, but they did. Well, the intent was from what, it's going to go, does it end up going before a jury on what was the intent of that?
I don't think so, Your Honor, and I understand if we didn't have the requirement that you put that in there in Section 707, that you state your intent, that might be an issue. But it's required, strict adherence should apply here, and that's just one of multiple requirements that this email doesn't fit in. So choose your favorite idiom, horse of a different color, square peg, round hole. This email is not a Section 707 election, and we know that by applying the email to what's required in Section 707.
Well, thank you both for your arguments. It's a really interesting case, well argued, well briefed, and the case is submitted.
Thank you very much.
That will end our oral argument for today. I want to thank the clerk down there for sticking with us for all week 7. Thank court officers, and we'll be in recess.